What's up, brothers? Your boy Mike Muse. Welcome to the conversation, the Mike Muse Show. I am so excited to be in conversation with my frat brother. Yo to the noobs of Kappa Alpha Psi Fraternity Incorporated out there. You guys loved him. And so I had to bring him back again for the second time. And he promised me that he will come into the studio so that we could do this inside the studio. And I can't wait to have him on there. But he was brilliant the last time that he came. And he really helped us really understand the role and functionality of a jury, but he came to us to really talk to us about the importance of us serving on a jury and the importance of having a diverse jury and what that means. And we kind of, if you guys remember, we unpacked a lot of things that happen with gentrification. What does that look like? And the pros and cons of when you don't have a jury that's reflective of one, the community and of the defendant at hand. But I had to bring him back because obviously the biggest talking point and takeaway from the Trump verdict that happened on Thursday with delivering 34 counts of guilty verdict was the jury. What was the jury thinking? Were they deciding? And as you know, audience, I'm leaning a lot into the jury instruction. I think that's one of the most important roles of a judge. And I had to have my brother come back and just unpack that because he is the expert on that. Will Snowden is the founder and director of the Juror Project. I was very careful because he did check me. Not Jury Project, but Juror Project on that. And it's a tongue twister for a guy from the Midwest who has to draw. So that's a little bit challenging. But without further ado, welcome back to the Mike Muse Show, Mr. Will Snowden. What's up, Newt?
What's happening, good brother? Thanks for having me.
Man, how you feeling right now?
I'm doing well. It's a really exciting time because a lot of people are having conversations about the criminal legal system. A lot of people are talking about our juries. And so I always want to capitalize on that energy when there's an increased interest in the work that I'm working on a daily basis. It's exciting.
Before we even get to what we really want to talk about, when you created the Juror Project, could you ever have foreseen the moment that the juries would be almost a trending topic?
Never. But it's exciting because people's perspective of juries is often from a negative lens. But as we are seeing with every high profile case we have, there's so much power in a deliberation room. And it's really exciting for me to see national conversations about the vitality and the importance of juries. And whatever the case is, if we're having honest conversations about the role our juries play, not only in our criminal legal system, but also being kind of examples of small little democracies, I think it's really valuable for the engaged folks in our communities.
I couldn't agree more. We are experiencing living history, Will. I was just talking about that a few moments ago. And I was just saying, we're living in a time that, you and I and everyone who's listening, we studied that in middle school. We studied U.S. history in high school. Some of us AP European history. Audience, I just remember I didn't talk to you guys about how I was going to connect the dots to AP European history. Oh my God, I'm going to bring that into play with Will's. I had so much to talk to y'all about just a few minutes ago. I forgot about the AP European history, but we had AP European history, US history, and these things we learned about the 1800s, Will, and the 1700s. And if I'm not even crazy, Will, but our grandkids will be unpacking this particular period of history that we're living in.
Yeah, this is unprecedented. But also, I think the reality of our politics is just different than what it used to be. And when we talk about our Constitution, there's two different kind of camps of interpretation. You have those who describe themselves as originalists, so they try to really interpret the framing of the Constitution through the lens of the framers when they actually drafted the Constitution. Then the other camp are people who are non-originalists. They view the Constitution as a living and breathing document to kind of keep up with the times of the country. And as we're talking about constitutional interpretation and constitutional application, it's really interesting to see how this document has stood over the course of time.
Well, you just let me right to my AP European history segue, because now that you brought in the Constitution, talk a little bit more about why, the founding fathers. And I've already qualified, Will, a few moments ago, no matter what you thought about the founding fathers, the character, slavery, all the things, right? Like there was still this narrative of like creating this union that was imperfect, but the way that it was structured through the amendments, we can always make it more perfect. And
right.
What I want to bring in AP European history is that, we studied so much of the monarchy system. We studied about kings and queens in Europe, and our founding fathers wanted us to go away from that. So if you could, Will, just talk about why it was so important to have that departure from a monarchy to the Constitution that they created and they structured, and their intent on this Constitution.
Right. There's danger when power is centralized, right? And when the monarchy, we have a king and all that centralized power and no accountability and acting with impunity, that's something that the framers of the Constitution wanted to get away from. So when they were structuring our Constitution, they very intentionally designed three different branches of government. We all know what they are. The first one is not the presidency, it's the legislative branch. Article 1 is the legislative branch, which symbolically is a signal to remind us that the power in this country resides within the people and the folks that they represent in the legislature. The second article is the executive branch, and Article 3 is our court system. And so this idea of framing a different type of government where power is actually dispersed amongst different entities, and there being this system of checks and balances, is something that was designed to prevent the country from ever going back to the terrors of a monarchy or the terrors of a king.
That's AP European history, right? That was a link I was trying to I wanted to make with you, because as we think about there's something about the framers of the Constitution, the thought that the American citizen was going to be one of the guardrails to our society, to where we wouldn't allow someone who had, or entities or parties or persons or groups, put self-interest ahead of the American people. And when you think about it, it's almost as if the framers couldn't have even imagined what we just went through a couple of days ago, because
Right.
they would have thought virtuous dynamics would have taken place, and that the American citizen would have been the guardrail. But that seems to have not been the case as of recent.
Yeah, I think when talking about the office of the presidency, the framers of the Constitution designed the ultimate check on the president to be impeachment. And impeachment can then lead to removal. But what's interesting, we have to remind ourselves what we're talking about with Donald Trump. We're not talking about actions that he took while he was the president. These were actions that he took while he was an everyday citizen, right? And we know from a variety of different cases that presidential immunity does not apply to acts that took place before you were actually the president, right? And so in the Donald Trump case, it was all about activity that took place prior to the presidency. And so the notion of a check and balance from a government perspective being the tool of impeachment, that was already used while Donald Trump was in fact the president. But we're not talking about that system of checks and balances from a government perspective. With our jury trial, the criminal trial that took place in New York, we're talking about checks and balances as it relates to holding people accountable in our communities when they have violated the law.
Mm-hmm. So you brought in the trial. So part of our co-equal branch of government is the judiciary. Talk to us about the role of a judge, in particular Judge Marchand, and why it's important as we go to the ballot box in November. Why is it important for one, pay attention to judges who we vote for, because what is the true role that they play in terms of managing the court? Because a lot of times we, as an average American, may not really understand the true significance of the judge, right? They're more so than just to say sustain or overruled some sentencing guideline.
Right. I think a lot of us are familiar with this kind of analogy that judges are like umpires in a game, right? They call balls and strikes, whatever it might be. But we have to expand beyond just that. First, let's start from the principle and reminder that judges are lawyers themselves, right? You can't become a judge in criminal court if you weren't previously a lawyer and had passed the bar. So they are trained lawyers. They've gone to law school, and now they're assuming the position of a judge. In trials, in criminal cases, judges are literally the ones who are deciding what the trial is going to look like. So that can relate to what type of evidence is admissible, what type of testimony is admissible, what are the things that are going to be presented to the jury through jury instructions. But as a lawyer, lawyers interpret the law. So the judge is interpreting the law. So when you have both a defense attorney and a prosecution making arguments about the law, the judge is interpreting what they think the best argument is as applied to the relevant law, and they're making their decision, which influences the arena of what the trial will actually look like.
And in this situation, how did you feel Judge Marchand did in that position that he was in?
I thought he was very professional, right? In every instance, he really conducted himself as a neutral judge, right? With the exceptions of times when there had to be discussions about what is allowed to be discussed outside of this courtroom and what is appropriate conversation and what is not. That's why there had to be a gag order that was put in place. Aside from that, I thought he really approached this from a space of neutrality, which is what we're expecting from judges, and that's what we were able to see with Judge Marchand.
Now, I got a question on Friday from one of my listeners, and I thought he asked a really great question. He asked me, did I think that Judge Marchand did anything that could warrant a strong case for appeal? Now, granted, we understand every person has a right to appeal.
Right.
And of course, we know the game of former President Trump, a tactic and strategy with them is to delay as long as possible. So we all know, can assume that an appeal is coming. So, but besides from the strategy and the political dynamic of that, did you see anything that could be grounds for a strong case for appeal?
In reviewing the case, the one thing that caught my eye as being a potential area to explore as a legitimate ground for appeal is as it relates to the timing of this prosecution. So in the state of New York, there are statute of limitations, and statute of limitations essentially prescribe the time period in which a person can be charged with the crime. According to New York criminal procedure, for felony cases, it is a 5-year statute of limitations. For misdemeanors, it is a 2-year statute of limitations. We are aware that this hush money was paid in 2016, but this trial just happened in 2024. So we have to ask ourselves, how did this prosecution proceed outside of this 5-year statute of limitations period, right? When we look in that statute, in the Code of Criminal Procedure for New York, it identifies when the clock can stop in terms of counting time for the statute of limitations. And there's two main prongs of when the clock is going to stop as it relates to counting up the time to 5 years. One prong is if the defendant's whereabouts are unknown. Well, that doesn't apply to Donald Trump. He was in Washington, D.C. at the White House. So the court knew where his whereabouts were. The second is if the defendant is outside the prosecutorial authority of New York for an extended period of time, right? And that's what we had. Donald Trump was in Washington, D.C. for the most part, in the White House, outside the prosecutorial jurisdiction of Alvin Bragg, the Manhattan District Attorney. Not only was he in Washington, D.C., Donald Trump, as a president, traveled around the country, traveled around the world, and did occasionally visit in New York. And so it's going to be a really interesting appeal to decipher how the time was calculated. Now, this term continuously does not, at least one appellate decision that I read, does not necessarily mean that it has to be like uninterrupted. Like you can have, the approach isn't necessarily going to be, well, he was president for 4 years, lived in the White House for 4 years. So that means that the time was clearly 4 years. There's been some disagreement in terms of whether or not time actually starts running again when Donald Trump was physically back in New York or not. So that's the one issue that kind of piqued my interest, is as it relates to the statute of limitations and whether or not this prosecution proceeded within that time frame, taking into consideration when the clock actually stopped counting towards the 5 years. Now, I didn't do the math, the district attorney did, and the judge agreed that this prosecution was able to proceed within that 5-year period because of how the clock stopped over that course of time.
Yeah, I've never heard this theory before, and I think that's brilliant. Audience, you see why I brought Will on? Because that makes sense. I'm wondering, Will, as we are thinking about the hypothetical of what a legal ground could be for an appeal, do you think it had anything to do with unable or it hadn't been settled law as if a sitting president could be charged and indicted?
I think, yeah, I don't know. That's a great question. I don't know what role that played in delaying the prosecution. I think the Manhattan District Attorney's approach felt very comfortable in his interpretation of the law that while Donald Trump was the president living in the White House, working as a president of the United States, that was a clear tolling or stopping of the clock towards this 5 years. And even though Donald Trump maintained his residency in New York, that did not necessarily mean that his residency allowed the clock to continue to run. We are familiar that if you are a sitting president, you're not going to be indicted while you're a president, but that does not necessarily mean you can't be indicted afterward.
Nor has that been resolved yet, neither by the Supreme Court, which is what
Right.
we're waiting on. So now let's enter politics a little bit, because audience, during that time period, Alvin Bragg was a Manhattan district attorney. It was Cy Vance who was a Manhattan attorney. And what we've seen, Will, is that Cy Vance, for whatever reason, decided not to move forward with bringing any charges. You don't have to say, well, I did yesterday. That could have been a political reason why he didn't move forward, because that narrative of fear of favor, right? And so was the question of fear of favor involved in his decision not to, or did he just not have all the evidence or saw the evidence differently than what Alvin Bragg saw?
Yeah, and it's important to remember that the charges that were brought against Donald Trump, falsifying business records, that's a misdemeanor in New York, unless the falsification is done to cover up some type of a crime. And that's why it was actually felony charges. Now, you bring up Cy Vance, which is interesting because there was a United States Supreme Court case called Vance or Trump versus U.S. And in that case, what was being challenged, and I'm sorry, I might have my case title wrong, but regardless, it involved Cy Vance and Donald Trump. And Donald Trump was basically, while he was a president, had received subpoenas for his personal financial records. And the whole question was whether or not he had to respond to these subpoenas for the financial records. And the Supreme Court says, yes, you have to respond to them, but you can challenge them just like you would challenge any other subpoena, right? And there are legal grounds in which you can try to quash subpoenas, but just saying that you are the president of the United States and not representing that these subpoenas are taking you away from your responsibilities of the president of the United States, that doesn't mean that you don't have to respond to them. Challenge them, fight them like you would do in any other instance, but don't just assume you can claim presidential immunity over those documents when those documents are related to things that happened before you were actually the president.
So let's get into the importance of jury instructions. And so, audience, I'm kind of going to take us through a story here. So now we understand the importance of a judge, how they control the courtroom. But the next thing is, to me, one of the most important functions of a judge is jury instructions. And as we know, audience and Will, is that the jury asks for jury instructions to be read back. And so I'm just wondering, why is the jury instructions so important?
The jury instructions are so vital and important because we don't teach people how to be jurors. We don't teach people how to deliberate. We don't impanel 12 lawyers who are familiar with the law, understanding what they need to do. So you have to instruct the jury to give them guidance in terms of what their responsibilities and obligations are during this deliberation period. Obviously, during the trial, their role is to sit and listen and just kind of hear all the evidence that is presented towards them, as well as hear all of the defense that might be presented as well. But when it comes down to deliberation, you have to be reminded of what the charges require and discussing and deliberating whether or not the elements of those charges were in fact met. The judge in those instructions, and I'll remind people, these instructions were 55 pages long. And the jury, according to New York law, is not allowed to take those instructions back with them into the deliberation room, which, to your point, Mike, is why they had to ask questions to be reminded about certain things. But these instructions are really providing the framework and the guidelines of how the juror should do their job during deliberation to decide this ultimate question, whether or not the prosecution has proven their case beyond a reasonable doubt. And if they have, then you can vote guilty. If you don't believe they have met their burden, then you can vote not guilty.
Talk to us a little bit about, not every judge is appointed by, it's not every judge goes to the bench by appointment. A lot of judges are elected. And so obviously you can't ask a judge how they would, you can't ask a judge while they're campaigning, how would you rule on certain types of cases, right? Because they don't know unless the case is before them, so they can't pontificate on that. But I'd like to give my audience ideas on types of questions that they could ask to get an understanding of the judge's constitution, right? Like, what movies have they seen recently? What books have they read? Like, who's their favorite music artist, last concert they've gone to? What do you think a good question could be as, these judges are going to be on the ballot in November, in some state, in some city? What
Hmm.
do you think my audience should be thinking about and questions they could ask to get to how a judge's constitution would be and how they deliver jury instructions?
Yeah, I think um, something that I would be interested in is really trying to first ascertain or ask questions that gives insight into that lawyer's experience going to trial. How many trials have you conducted to verdict? And when I say to verdict, that means that the jury actually came back with the verdict. And just for awareness, you can start a trial, give opening statements, call a witness or two, and then in the middle, the prosecution and defense agree that actually we're going to plead this case and we're not going to take it to trial. So you want to know how many cases themselves have they tried to verdict, because that's going to actually provide some insight into their familiarity of communicating with jurors, right? As a lawyer, your job is to talk to 12 jurors in a persuasive manner for the party that you are representing. There's also a candor and a level of deference that I think is really vital for judges to have with jurors. And interestingly, trying to ascertain how much are you going to respect when a jury says, we are deadlocked and we can't deliberate anymore to come to an agreement. And the reason why I bring this up is because one of the interests that judges have while they are on the bench is what's called case processing. They want to go through their cases. Now, a measure of justice is not the efficiency in which you process cases on your docket, right? But sometimes judges get concerned when their dockets are really, really large, and then you have a case that's going to trial, and the only way that case is getting off your docket is if it goes to trial. And then you've done this trial, let's say it's a week long, and the jury says, we don't have a unanimous decision, so this has to be a mistrial. And sometimes the judges will try to kind of browbeat the jurors into coming to a verdict. And I don't think that's appropriate, right? As you can certainly encourage them to deliberate, take their time, ask their questions, and don't rush that process. But if they really have come to a point where they just can't come to an agreement, then that is actually valuable information. One is valuable information for the prosecution to perhaps reevaluate the strength of their case. It's valuable information for the defense and the defense attorneys to perhaps consider what went well in their case, and maybe that case could resolve by a plea deal for a lesser charge, or perhaps they're just going to have to do the trial again. So I think knowing their experience going to trial, trying to assess, what level of deference would they give a jury when they're presiding over trials, are all good information and questions to gather.
Yo, that is brilliant. Because, well, I've been thinking about, how I wanted to cover what happened on Thursday. And no matter which side of the aisle audience you fall on, no matter if you're excited that he was found guilty or you're not excited you're found guilty, I want to know, like, I want the audience to take away for all of us is to be, what are next steps?
Mm-hmm.
What are next steps that we can do to help ensure that the justice system becomes more just, remains just? And a lot of the times, well, I'm always talking about how a lot of us have opted out of democracy. And so out
Mm.
of democracy, we put judges on benches who should not be there,
Mm-hmm.
who would not have given fair instructions. And we think that we don't have a role in this. And so
Right.
while emotions are high right now and people are feeling something, I wanted to teach our audience, Will, about what are actionable steps that can be taken in November,
Mm-hmm.
keep us engaged in our democracy and to translate whatever emotion you have right now into the actions of voting.
Yeah. Yeah.
And so the takeaways you've been giving right now, Will, I think have been priceless. And I'm going to flex a little bit and say no show has ever talked about this before in this capacity because they
Yeah.
haven't will yet. Thank God I found it before you become too famous for the Mike Muse show. But really quickly though, Will, what is your assessment on how quickly the jury came back?
Right. They went out to deliberate Wednesday, came back Thursday afternoon with a verdict. That's a quick verdict, especially for a trial that lasted 4 weeks. And we have to understand this was not a very complex case, right? It was very kind of clear what the allegations were, what the evidence was to suggest that Donald Trump did in fact falsify the records. When I got the news that the jury had come back with the verdict, I already knew that that was positive for the prosecution. In my experience as a criminal defense lawyer, when juries come back quickly with a verdict, 9 times out of 10, that is in favor of the prosecution. Now, I did have one trial where the jury came back 13 minutes not guilty. Not saying that that doesn't happen, but more often than not, when that does happen with the jury coming back with a verdict fairly quickly, that's an indicator that the prosecution is likely going to secure some form of verdict.
I love this. So it came down to, it was a clear-cut case. The evidence was strong. And not only was the evidence strong, clear-cut case, it was easy for the jury to digest.
Exactly.
Okay. Well, so that means thank you so much for your brilliance, man. Thank you so much
for
having this with us, going in this direction, and giving us all like tangible takeaways that we can use into the ballot box come this November. I can't wait to be back, man.
Yeah, I appreciate you having me. If there's one thing I could share,
oh yeah, sure.
I want to be defensive of these 12 people who took time out of their lives to interpret all of the evidence, go through the jury deliberation, go through the jury questionnaire. And it's really frustrating for me to see people to call into question the verdict, right? You can disagree with it, you can agree with it, but we cannot ignore the fact that there were 12 people, not one person, but 12 people who came to a unanimous decision that Donald Trump was guilty. And so when I hear commentary about the system being rigged and that this prosecution was politically motivated, I think you can have those opinions in terms of the origin of the prosecution, right? But we can't apply that stuff to the verdict that these 12 New Yorkers were able to come back with. Additionally, when we are thinking about what has been the response to the verdict, I have not heard one person declare that Donald Trump was innocent. They've attacked the process. They've attacked the motivation. They've said the real verdict is going to be the election. And so what's important for me is that we do not negate the sacrifice that these jurors, these 12 New Yorkers, and actually I think it was 16 New Yorkers, because I think there were 4 alternates. Like we can't illegitimize what just happened. And I get really frustrated when the distraction is being for this case is being focused on the potential politics behind it and not having a deference for the actual process that was conducted.
And that is why you created the Juror Project, because you are a defender of jurors.
That's right.
Will, how can people reach you?
The website is www.thejurorproject.org. Instagram is probably the best way. It's easier, at Juror Project. So that's at JURORPROJECT.
All right, well, thank you for everything. Stay right there. Audience, until next time, have a wonderful Saturday. Enjoy the rest of your weekend, and I'll be back to speak with you all on Monday. So until next time, peace.